Mr. Sandeep Chaki, where is you? Where are you? Who is the person? Mr. Sandeep Chaki, please identify.
My lord, ওনার ভিডিওটা
Video.
আনমিউট করুন। He will
Yes, my
unmute.
lordship.
Where are you? Sandeep
I'm
Chaki,
in. Yes.
please put on your video. Tell me one thing. I have a complaint
Ah,
dated 11th of September 2024 in front of me.
yes.
What do you do?
Actually, ma'am, I'm an advocate as well as the public prosecutor senior panel, Government of West Bengal, Siliguri Court. And I
In
am
which-
lodged a written complaint on 11th September. My lord, I lodged a written complaint. The contents is genuine.
I
But
do
I
not
due to
want to inquire about the genuinity of the contents, right?
okay.
Just tell me, did you prepare the complaint yourself?
Yes, yes,
Are you sure?
yes, ma'am.
You are the public prosecutor of the state of West Bengal. You are
Ah,
defending the state of West Bengal,
ha.
right?
Ma'am,
I will
yes,
read
right.
out the complaint.
Yes.
Do you have a copy in front of you?
Yeah.
Yeah? What does yeah mean? You are the
Ma'am,
public prosecutor? This is
I
the
have.
way you address a court?
My lord, I have my written complaint original in my custody, ma'am. Original written complaint.
Do you have it in your hand, in your mobile, something in
Original.
front of you? I do not want the original. Do you have a copy?
At this moment, ma'am,
You do not have, your
my
advocate
own
is there.
possession
Who is
is
representing you are there? You
written
have a
original
copy with
complaint.
you?
My
Please read out.
chamber, ma'am.
Please read out. Let everybody hear what is the complaint and the manner in which the police is proceeding. Right? Please read out.
I, Sandeep Chaki, son of late Sudhanshu Chaki, public prosecutor, Siliguri Court, Government of West Bengal, would like to lodge this FIR against above named accused person to the following effects. Since few days, I noticed one video footage became viral on.
1 minute. Is it B?
Yes, my lord, it will be became.
He is a public prosecutor. Do not smile.
My lord, maybe that.
I am going to take serious steps against the complainant if something comes out.
My lord,
and it will be there.
My lord, the drafting was done by his junior. So
His junior? He is the complainant. He doesn't know what is there in the complaint. Whatever somebody else has drafted, he signed it.
My lord, my lord.
Let me see how many inadvertent steps are over here. Right? So, first one, we'll calculate one by one. This is the first one. Became is not there.
My lord.
Right? Then go on.
Viral on social media, YouTube, some code is there where above named Sudha Sil Ghosh uploaded was.
Yes, whatever.
One defamatory basis video with malified.
Yes, stop. What is the spelling? Number 2 error? Number 2 error? Very well. Next.
To harass the government of West Bengal, publishing the viral fake video in respect of judgment of Honorable Supreme Court of India.
What is the spelling of judgment? Is it right?
He had
extra added. Number 3 mistake. Then
also made ridiculous comments. This video as well as media was made to injure the image of government of West Bengal as well as Honorable Supreme Court of India before the public in general.
Before the public in general. What does this mean? Before the public in general? And P becomes capital, G becomes capital. He is the public prosecutor of the state. Had it been any Tom, Dick and Harry, the court would have simply ignored this. But he is holding the post of the public prosecutor. Defending the state is his responsibility. Next.
This will create the breach of tranquility as well as the breach of peace in public in general.
Same mistake, public in general.
This act violated the provision of Indian Constitution and provisions of BNS.
All P's are caps, not required.
Therefore, it is humbly prayed before you that you will be pleased to take necessary action against the above named accused person, Sudha Ghosh, as mentioned above, as per the provision of appropriate legal forum, and you will
Right. Now, what is the allegation? That somebody has placed certain video in the channel,
social media.
In the social media. Now, if somebody uploads something, it is not the responsibility of that person to make it viral. It goes viral. The social media, the society at large maybe forwards it to such extent that it becomes viral. What does this person have got to do with it?
That is subject to investigation, my lord. Whether
And
he
you
intensely
have made it in such a manner, you are the public prosecutor. Once again, I'm saying, you have done it in such a manner, you have placed it as if the offense has been established. Is it so?
maybe that the language is indicating to us what my lord has suggested, but
does it not indicate it to you? Does it only indicate it to the court? Is it such a complaint on which the police is required to act? There are so many complaints or so many videos which goes viral, right?
That's why, my lord, police has given a notice for to the petitioner to appear so that they can investigate the matter. No power. It's not the case that police has gone and arrested the accused person. These are all
You want these are all
available section.
No. Not
just imagine.
No,
This
I
is
don't
your
have the FIR, my lord.
submission.
I don't have the copy of the FIR right now.
This is the complaint.
Complaint
You have made it with a particular purpose. And you know what the end result will be. It's only because you are the public prosecutor, you're appearing for the state, that does not give you any right to come up with any baseless allegation against anybody. And that too, this type, is this the standard of a complaint written by a public prosecutor? The state shall take steps. He is simply not fit to be given this post. How was this person appointed? Just pick and choose? Was any examination conducted?
No. For appointment of this, there is no such.
There is no such examination. How is the state spending money upon these type of persons who are not fit to make a complaint?
That the legal remembrances based on the practical experiences and exposure.
The legal remembrance took the practical experience and exposure of this person?
This is the general practice.
Now, this practice is required to be changed.
That is, my lord, if the LR manual speaks in this way.
The state government has to take steps. Would the state government appoint a person, engage a person with this merit to act as the public prosecutor? Somebody else writes a complaint, prepares a complaint, and the PP signs it, and this is the designation. Had he not written his designation, it would have been different.
Yes.
He describes himself to be the public prosecutor. It is he to whom the police comes up with all types of instructions. He is defending the police.
That hinted me also. Very true. That designation ought not to have.
Yes. Now, once the person has...
As an individual capacity.
Yes, he could have done it.
That I
the court would have ignored everything. But it is only because he is trying to make use of his designation as a public prosecutor that the police is taking steps. Is it proper?
No, madam. That is not also. I will explain, madam. That part I will explain. I'm coming after that.
But relying on this complaint, I do not think the police should have taken steps.
I will make my...
Very well. Next, Otri Sharma. Where are you?
I'm there.
Yes. And what is your occupation? What do you do?
I'm a legal practitioner, Lordship.
Yes.
In Siliguri.
In Siliguri.
Yes.
Right.
What
prompted you to lodge this complaint?
Lordship, when I saw this YouTube content, being a legal practitioner, I just thought that is derogatory to the entire judicial system, which is last resort of common people in India, considering the scenario. So I just informed the police station. I have not written anything except that what he has stated in his video. Nothing else. I have just informed. I don't know what sections are there and all. I have just informed police that this thing is on.
Tell me one thing, is this the first complaint that you have lodged before the police, or these types of videos come on regular basis? Did you ever lodge any complaint?
I have seen this and I lost this. See, I was
So
not
this is the
after this
first complaint
question.
that you have lodged. Have you
Yeah.
ever seen or heard the speeches given out by the political parties against the judges and the judiciary?
Yes,
Have you ever
Lordship. I have
heard?
seen.
Did you
Yes,
ever
I have.
lodge any complaint?
No, my Lordship.
When the political parties members come out in open public and they declared that they will not follow the court's order, they are not going to comply the court's order, these judges are related to political parties, they give out whatever the directions the political parties give them. Have you ever lodged any complaint against these type of political parties?
No, my Lordship.
No.
Never.
All on a sudden, you lodge a complaint against this person and he claims...
I have nothing against this person.
Are you seriously interested to proceed with your complaint?
I have just informed the authorities about
Do
this sort
you
of thing.
still intend to proceed with the complaint?
Yes, I am, my Lord.
You are still interested to proceed with the
Yes,
complaint?
yes, Lord.
Yes. What exactly is troubling you?
Nothing. Being the part of this entire system, I thought this is derogatory. Nothing
What
else.
is derogatory? Will you please say? Which portion? Which portion troubled you?
He was telling that Chief Justice of India was in collision with few political personalities and he is the worst Chief Justice ever and he should be impeached and he's hand in glove with the government and he's just ruining all the cases. He has taken up
Did you bring this to the knowledge of the Chief Justice of India? Chief
Not
Justice
yet,
of India is still holding the post. Did you bring this to the notice of the Chief Justice that this is the comment that is being played by somebody?
Not yet, my Lordship.
Not yet.
But I
Why
will.
don't you take steps? Bring
I
this
will.
to the notice of the Honorable Judge.
I will take immediately, my Lordship. It was my fault, but I will initiate immediately.
Now the state. Yes.
My lord, firstly,
My lord,
my lord,
before this start, may I only
Yes, please.
bring
1
one
minute. Yes.
provisions
Hmm.
to your lordship's consideration. That is the provision of 215 of the BS, which clearly bars a complaint for be registered under section 267 has to be by the court itself.
All right.
So lordship, kindly come to 215 of Bharatiya Nagarik Suraksha Sanhita.
Yes.
May I read this section for you, lordship?
Yes, please.
Lordship, 215 says prosecution for contempt of lawful authority of public servants, for offences against public justice, and for offences relating to the documents given in evidence. It starts with no court shall take cognizance of any offence punishable under section 206 to 223. Thereafter, lordship accept the complaint in writing by the public servant. Second part, which is here, B1 says, no court shall take cognizance of any offence punishable under any of the following sections of the Bharatiya Nyaya Sanhita 2023, namely section 229 to 233, both inclusive, 236, 237, 242, and 248, both inclusive, and 267. That is the first section which is given in both the complaint. When such offence is alleged to have been committed in or in relation to any proceeding in any court. Now, lordship, except on the complaint in writing of that court or by such officer of the court as that court may authorize in writing in this behalf, or of some other court to which that court is subordinate. So, lordship, there is a specific bar. If it is an insult on the judiciary or the Chief Justice of India, It is for the Honorable Chief Justice of India to register the complaint, or any person authorized by him to go and register this complaint under 267. Like Lordship knows that earlier provisions of 195 of CRPC related to the defamations. Earlier, these sets used to come with the sections of defamation. Everybody and anybody used to come, and usually they used to write that my leader has been insulted, that's why I have been defamed. So, Lordship, there is a series of complaints which were stayed by our court, since it was in violation with the provisions of earlier 195. Now, Lordship, in this regard, I have twofold of submission. Now, what is 267? 267 is the perimeteria with the earlier code 228 of IPC. Section 257-67 says intentional insult or interruption of public servant sitting in judicial proceeding. Whoever intentionally offers any insult or causes any interruption to any public servant while such public servant is sitting in any stage of judicial proceeding shall be punished with the simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 5,000 rupees, or with both. Now, Lordship, I want to draw your Lordship's kind attention to one judgment of the Supreme Court. This is only one paragraph. I want to draw your Lordship's attention. It's 1983 4th Supreme Court cases 701. How a criminal motion starts. Lordship, kindly come to paragraph number 5. Only for this purpose. It is thus clear that anyone can set the criminal law in motion by filing a complaint of the facts constituting an offence before a magistrate entitled to take cognizance under section 190, and unless any statutory provision prescribes any special qualification or eligibility criteria for putting the criminal law in motion, no court can decline to take cognizance on the sole ground that the complainant was not competent to file the complaint. Section 190 of the Code of Criminal Procedure clearly indicates that the qualification of the complainant to file a complaint is not relevant, but where any special statute prescribes offences and makes any special provision for taking cognizance of such offences. Under the statute, the complainant requesting the magistrate to take cognizance of the offence must satisfy eligibility criteria prescribed by the statute. Even with regard to the offences under Indian Penal Code, ordinarily, anyone can set the criminal law in motion, but the various provisions in Chapter 15 prescribe the qualification of the complainant, which would enable him or her to file complaint in respect of the specified offences, or no court can take cognizance of such offence unless the complainant satisfied the eligibility criteria. But in the absence of any such specification, no court can throw out the complaint in decline. In this case, there is specification that who can be the complainant. Now here, any person ABC cannot go and say the police that take the cognizance of this. Lordship, this particular offence has now, I have twofold of submission. This entire complaint is based on section 267. Rest other section 353 and 352 are not at all attracted, and Lordship, I will rely upon one judgment of Supreme Court in Patricia Mukim, where it was dealt in the light of Patricia Mukim, light of the 153A and 505. Lordship, know what is that for the... There are two parts. One is the procedural part, where the complaint is barred. Another is the substantive part. What is required to constitute this offence under section 228 of IPC, or now under section 267 of the Bharatiya Nagarik Nyaya Sanhita. Now, Lordship, as I said, that this complaint, once our court in 1967 had decided, in judgment of Justice N.C. Talukar in Shubhranshu Kanti Acharya versus State, 1968 AIR 1968 Calcutta 249. Lordship, here the provisions just are substantially here. One of it was brought before the court by the court itself. Kindly come to the facts once. The revisional application is against the order dated 17 January 1966, passed by Sri such and such, the learned subdivisional magistrate Malda, in case such and such summoning the accused petitioner such and such under section 228 of the Indian Penal Code 1860 and drawing up the proceedings against him thereunder. The facts of so it was initiated on the basis of the summon issued by the judge. Now, Lordship, kindly come to internal page 4. Lordship, this is 252 page 4. Lordship, I will start from here. There is a line, a reference in this connection. Lordship, got it?
Yes.
A reference in this connection may also be made to the case of Pachai Singh versus State, AIR 1959, Allahabad 693, wherein the procedure as laid down in section 480 and 482 of the Code of Criminal Procedure as discussed in details. Justice M.C. Desai has held therein that cognizance of an offence punishable under section 228 of the Penal Code 1960 can be taken on a complaint of the court concerned, or the offender may be dealt with by the said court as laid down in section 480 and 482 of the Code of Criminal Procedure. Section 480 of the Code of Criminal Procedure is only enabling section to confer power upon the court concerned to publish an offender summarily instead of having him tried regularly on the complaint. So there can be three places. One, on the basis of it, he can always bring this into the notice of the Honorable Chief Justice of India if he feels that this is so derogatory to the judiciary, because this is on an ongoing proceeding before the Supreme Court which is going on, and where everybody of the world is interested in that proceeding and they are making the comments. So in each and every cases, if third parties goes to the police station and police starts registering the complaint against the private individuals, then Lordship, then it is completely barred and this is not permitted under the code. Now, Lordship, my humble submission is that in the view of these judgments and the law, procedural as well as the substantive, this complaint should go today itself and it should be quashed. Because the cognizance cannot be taken, where the cognizance cannot be taken by the court, then police cannot, what would be the usefulness of this registration of this particular FIR?
What is the ratio in Patricia that you are relying upon?
Yes, my lord. Patricia, Lordship, I'll be... Lordship, ratio of Patricia, Lordship, it's coming 14. India, paragraph 14, India is a plural and multicultural society. The promise of liberty enunciated in the preamble manifests itself in various provisions which outline each citizen's rights. They include the right to free speech, to travel freely, to settle. Throughout the length and breadth of India, at times when the legitimate exercise of such right individuals travel, settle down the carry of a vocation in a place where they find conditions conducive. There may be resentment, especially if such citizens prosper, leading to hostility or possibly violence. In such instances, if the victims voice their discontent and speak out, especially if the state authorities turn a blind eye or drag their feet, such voicing of discontent is really a cry for anguish, for justice denied. Lordship, there are not only the allegation against me that I have insulted the judiciary, but complainant in the first complaint also say this is an insult for the state of West Bengal. Now, whether my critique or any view, I may say anything on judiciary, it is the judiciary to take cognizance of that. Maximum, I can be proceeded under the Contents of Court Act. There is the provisions under Contents of Courts Act, and the judiciary can take it. Now, Lordship, here I may be critical about judiciary, and Lordship, this I have a right to do so. until I am prosecuted by the proper authority. In such instances, the victim voice on discontent and speak out, especially if the state authorities turn blind eye or drag their feet. Such voicing or discontent is really a cry for anguish for justice denied or delayed. It is exactly what happens to have happened in this case. The attack upon six.
Very well. I have followed your submission.
And now, Lordship, the Lordship knows even in Bhajanlal, where there is no case made out at all, where the another thing, Lordship, where that there no fruitful result would be achieved by continuing the case, because trial cannot be permitted to proceed. Lordship, this complaint.
Yes. Has any other complaint of such nature been filed elsewhere? Are you aware?
Yes, my lord, in South Bengal, in Bardwan,
Against the same person?
against same persons.
In
Their
several
matter is
places.
going on before court number 759.
Not only in this section, there are other sections also.
They have once it was stayed by this court, on that day he received a summon that a section under POCSO Act has been added.
POCSO is something else.
Yes.
This has got nothing to do with
No,
the
in these two
speech, possibly. POCSO is something else.
There are two other sections also added.
Hmm.
With regards to this specific allegation,
Hmm.
other cases also
Hmm.
pending or
Hmm.
start
Hmm.
the other.
Hmm.
One by one, let me clarify, madam. I understand what is troubling. What is, my lord, I'll be, my voice will low down. I use the microphone. What is troubling to your lordship with regards to the first complaint,
Yes.
that disclosing the name to some extent the police personnel and investigation may swayed upon. And with regards to, and also with regards to the first complaint, my lord, the allegation against the state government, I have examined this entire video. I did not find any allegation with regards to this against the state government. The entire allegation of whatever the statement or the speeches in the news channel, kindly mark, that is a news channel, my lord. What the news has been published, my lord, is completely derogatory with regards to the, my lord, the pertains to a particular our present Honorable Chief Justice of India and the other judges also even. Now, my lord, kindly take up, kindly, your lordship has seen even, kindly take up the second complaint. My lord, I will not rather basically rely on the first complaint, brother, but kindly I will rely stress, I will give a stress on the second complaint made by Otri Sharma.
Yes.
My lord. আমার গুলো আমি নেব আমারটা my lord, it's not a report. My lord, may I read, my lord?
Yes, yes. I have not yet read it. The first one was so annoying
Yes, that's
that I didn't go to the extent of reading
that's why I
the
said,
second
my
one.
lord, kindly at this moment, kindly discard for this moment. Kindly bank upon this 13th September 2024. My lord, I, Otri Sharma, my lord, resident of such and such,
Yes.
would like to lodge this written complaint against a reporter stroke anchor named Suddhoshil of Priyo Bondhu Bangla Media, quote unquote, uploaded and circulated an offensive video against the Honorable Chief Justice of India in pertinence to the matter of RG Kar, which the Supreme Court took suo motu cognizance. That the reporter stroke anchor, as mentioned above, prepared a report and circulated the contents through communicable devices that are very much offensive, defamatory, and menacing in character. The manner in which the reporter addressed the Honorable Chief Justice of India is very disrespectful, and the full content of the said news report circulated by the reporter is false and caused annoyance, inconvenience, insult, injury, and criminal intimidation. Whereas the reporter actor intentionally made the false report by distorting the original. Kindly mark the distorting the original fact. Why I say, I will also say, and misrepresenting the false information to create enmity and hatred toward the society. Not only that, the media with malafide intention, circulate the news report challenging the power of the Honorable Chief Justice and also, in an imaginary way, threaten the public to agitate against the Honorable CGI solely. That is said circulation report where the reporter anchored alleged that the Honorable Chief Justice of India is not performing his constitutional obligations by delaying the process of justice to the public of nation. It was also alleged by the reporter that the Honorable Chief Justice is working as per his own hidden agenda and the CGI is intentionally lingering some cases, stroke legal issues according to his own sweet will without considering the gravity of the cases and law of land. That the reporter even alleged that the CGI is acting biased is additional word is in some selective issues. Thus, by circulating the said video, the anchor intentionally insulted the CGI of the country and the entire judicial system of the nation by provoking the public at large, which shall break the public peace and tranquility and created feeling of hatred, enmity, and doubt among the minds of the people of this nation. That the reporter anchor had stated in the report that the Honorable Chief Justice of India is the most tarnished CGI, in our judicial history, and the Honorable Chief Justice shall immediately be impeached from his chair. That the reporter also stated that the hearing of the matter of RG Court will not be listed before the Honorable Supreme Court and the RG Court will not get justice unless the Honorable Chief Justice is impeached from the acting CGI. That the entire report news is fake, which was circulated on social media to intentionally defend the Honorable Chief Justice of India and attack the dignity of the Supreme Court, aiming to incite distrust and disturb public peace. That the content published by the reporter in such a manner that it causes imputation concerning the Honorable Chief Justice of India, causing harm, hatred, and disturbing the harmony of society. Therefore, I request to kindly acknowledge the proper necessary action and permission. Now, Milord, this is the entire corroboration to your Lordship, because I do not want to invite your Lordship to open the video or the news in an open court, Milord. It is completely derogatory because I have seen the moment it has been seized by the police personnel, Milord, and for the necessary steps, Milord, I will come. No, I cannot even.
Don't reply.
Sorry, Milord.
Yes.
Now, Milord, this complaint we have received. But I said, Milord, for the moment, the first complaint to submit. This complaint we have received. Now, Milord, the police, this acted on the basis of the, Milord, the authority of the Honorable Supreme Court, Lolita Kumari. When the offense discloses the cognizable offenses, Milord, it is incumbent of the police authority to register the affair. There is no other option. Milord, had I been not registered after disclosing the offenses disclosed in a cognizable manner, then I would have been punished, Milord, in accordance with law. So, Milord, the moment I received this complaint, Milord, may I hand over the judgment. Milord, your Lordship has gone for my satisfaction. For a moment, Milord, I am handing over.
No, please don't hand over.
Milord, kindly
You go to the next submission. Go to the next submission. What will be your next submission?
Milord. So, Milord, the moment this complaint has come, then, Milord, this necessary section has been incorporated. Now, with regards to the 267, Milord, and the 353. Now, Milord, I will read, Milord, the provision with the new act, Milord. Milord, may I hand over, or your Lordship has a book?
I don't have a book. I do not see the new law over here. Ache?
Milord, I have a spare book, Milord.
No, I have. Yes, it's there. BNS. I. Yes. Which section?
My lord, the first 267 I will read.
Yes.
My lord, these 267 is a non-cognizable offense, my lord.
Hmm.
So, my lord, 267 what speaks of whoever intentionally offers any insult or causes any interruption to any public servant while such public servant is sitting in any stage of a judicial proceeding shall be punished with simple imprisonment for a term which may extend to 6 months or with fine which may extend to 5,000 rupees, both. Milord, 267 is, Milord, 267 is a non-cognizable offense, and the 353, Milord, is a cognizable offense. Milord. Kindly read the 353, Milord.
Yes.
Milord, 353, statements conducting to public mischief.
Tell me one thing.
Hello.
The issue in question is before the Honorable Supreme Court in a suo motu proceeding.
Milord.
Will it be proper to go into all these things by a different court at this stage?
Not, we are not, because the proceedings before the Honorable Supreme Court with regards to the incident took place on the very the day and the matter is being investigated, which is being monitored or supervised or under the scrutiny of the subject matter before the Honorable Supreme Court. Here is totally different, my lord. Here,
the main thing which you read out just now is that some person is alleging that the Supreme Court or the Chief Justice is not taking proper steps in accordance with law, delaying, whatever. The court is in scene of the matter.
Yeah.
If anybody has any grievance, that can be brought to the knowledge of the Honorable Court. Why proceed with a complaint
my lord,
over here?
I'm answering.
Because there are, this is there, you say, or no, it is better the complainant says it is there in the public knowledge, in the public domain. Today, a complaint is registered at A place, tomorrow at B place, then C, D, and it will continue
My lord,
throughout this country.
I will answer this.
Right? Does it make any sense? First. Second, suppose anybody, I, you, he, whoever, just says that such and such person is not doing his work properly. Does it make any difference to that person? It simply doesn't. The Chief Justice is not bothered about what is being stated about him. It is a position of authority. The court is acting in accordance with law. Why will the police bother himself or themselves with these frivolous complaints and trouble these people?
My lord, I will answer, my lord. First, your lordships, the query, when suppose now someone is not performing his or her constitutional obligation or what is the duties casted on him or her. First, my lord, the Suddha Ghosh, he made this is the statements of the news channel he published.
What is the credibility of this news channel?
Just a second, my lord. Then he ought to have, without delivering this in the social media as in the news channel, he ought to have approached the Honorable Supreme Court. This is number one. Number two, my lord. I kindly appreciate, my lord, when we are the, my lord, in the judicial system, my lord, in the administrative procedure, my lord, if someone makes any derogatory statement, which, my lord, I feel being insulted, personally.
What happens when
Lord,
the political party ministers on open air?
Equally.
Did you lodge any complaint against them?
Lord, if I personally, if your lordship say, I will, irrespective of all political parties.
Go ahead. How many are there?
I have not done anything, not either against any political party.
This should be. If this is the stand taken, it should be equal.
I am not here as in a personal capacity.
Yes. You are defending the police, the state.
My difficulty is that what I have acted. Now, my action is tainted to a malafide or bias or the abuse of process of power or authority. Then, my lord, it is amenable by your 226.
Yes.
Now, my lord, here, the Honorable Supreme Court even has come forward This is a press release. May I read the press release? In a significant development, Delhi police has registered an FIR in connection with an alleged malicious post on social media against CGI T.Y. Chandrachud's wife after a complaint was filed by the Supreme Court administration.
Right.
Yes.
Supreme Court administration.
That's the
Now, Milord, the Supreme Court administration has already taken a step, Milord, with regards to the other, Milord, malicious post. So, Milord, here, now, Milord, there is a complaint, Milord. There is a complaint. The state also can bring to the notice before the Honorable Supreme Court. There is one option. The other option is that, Milord, Lordship, kindly see whether my police has acted in even a overact or the Milord, or any other actions or any abuse of process of power. Here, Milord, the moment the cognizable cases has been disclosed, police registered the FIR, Milord. Now it is my duty to investigate, Milord. Now during the course of investigation, Milord, there are so many parameters or the procedures the state may adopt it, Milord. So very in the nascent stage. Now, Milord, the question next comes, this with regards to the section 267, whether the person against who has been, Milord, against the public servant is sitting in any stage of a judicial proceeding, he can come, Milord. And Milord, with regards to a section 174, Milord, 174 surplus 4.
Has this provision been invoked?
No, Milord. 174 surplus 4 said, in the new act, Milord, BNS. This is the BNSS Act, Milord, 174. That when there is one is cognizable offense, another is a non-cognizable offense, Milord. 174 surplus 4.
Yes.
Where a case relates to two or more offenses of which at least one is cognizable, the case shall be deemed to be a cognizable case, notwithstanding the other offenses are non-cognizable. So, Milord, here, what the police has seen with regards to the two sections which has been incorporated, the 267 and the 353. 353 is a cognizable offense. Now, Milord, with regards to a question of 267, whether the person who is agreed or against the public servant, this complaint is made, then already the FIR has been brought to the notice of the Milord, the jurisdictional court. The Milord, kindly see the provision of section 482.
No, 353.
353. 353B. 1B.
Yes. With intent to cause or which is likely to cause fear or alarm to the public.
Yes.
Or to any section of the public whereby any person may be induced or commit an offense against the state or against the public tranquility. What is there to cause fear, alarm to the public?
Yes, my lord.
What is the offense against the state, against the public tranquility?
Yes, my lord. Yes.
What?
If you see, my lord, if you hear the entire, my lord, all these, each and every word is being attracted.
When was this video put on air?
But I think in September beginning.
Because the complaint is dated 13th of September. From September.
Yes.
What is the unrest?
There are so many. Your lordship hasn't even seen within the entire state of West Bengal what happened, my lord.
What? Is it because of this video? Please,
I'm
sorry.
Lord, this is one of the video.
I do not accept.
This is, my lord, your lordship may differ. But my lord, kindly see in this news channel.
Yes.
10 lakhs members are the members and viewers. It has not been circulated by others. He circulated. His viewers 10 lakhs as of now. Today.
That is his credibility.
Very good, my lord. The credibility, I have a right, a constructive demonstration. I don't have a right of a destructive demonstration, my lord.
They
What
want
is-
to
please,
demonstration also.
please.
What
The
is this? I have not.
whether it is 10,000, whether it is 10 lakh, whether it is 1 lakh, it is for that person. What is the credibility of that person? The court
We
is
are
not
not,
aware.
because
We are not
We are
aware.
not. We are not.
What capacity he has to incite fear,
Malad,
cause
that is
alarm?
the investigating agencies
Nothing.
are investigating.
Let them investigate
Yes.
on their own. Do not disturb the person concerned. Whatever you've got to do, you do on your own. Don't
Malad,
disturb this person.
no, this is not a question of disturbance, my lord. My lord, may
You
I?
cannot, simply cannot.
My lord, when there is a disclosure of a cognizable offense, I will not investigate.
You will investigate with your mind,
Definitely.
not mechanically.
No.
This is absolute mechanical. You cannot do this. If you want to bring this to the notice of the Chief Justice, you can certainly do it. Nobody is stopping you. And you can do it. It's within your right. Defamation. Defamation is something very personal.
Defamation, this is not the question about defamation, because defamation, the person who has been affected.
Yes.
They should come up.
Right.
But here this section, the public in general, mass is being insisted and inflected with the statement, Milord.
Incited rather.
Milord, my
Sorry, sir.
one authority I will
Please
rely.
come.
One authority I will rely, Milord.
Lalita Kumari?
No.
All right.
This is a 2021, Milord.
citation to bol
2021-19, Milord, SCC 401.
Please pass on.
Milord. The paragraph, Milord, the 18, 17, Milord, I have only one copy, Milord.
All right, you read out the portions. Please read out the portions.
Yes, Milord. Milord, this judgment of 2021, Milord, this presided by the Milord Honorable Chief Justice of India and other two judges, Milord, where this entire scenario and perspective has been described with regards to the Faujanlal, Milord. Then this finding has come, the paragraph 16, Milord, and 17 and 18. An interim order of stay of investigation during the pendency of the quashment petition can be passed with circumspection. Such an interim order should not require to be passed routinely, casually, or mechanically. Normally, when the investigation is in progress and the facts are hazy and the entire evidence material is not before the High Court, the High Court should restrain itself from passing the interim order of not to arrest, no coercive steps to be adopted, and the accused should be relegated to apply for anticipatory bail under Section 438 CRPC before the competent court. The High Court shall not, and as such is not justified in passing the order of not to arrest and no coercive steps, either during the investigation or till the investigation is completed and or till the final report charge sheet is filed under Section 173 CRPC, while disposing the quashment petition under Section 482 and or under Article 226 of the Constitution of India. So in paragraph 17, I am skipping. Paragraph 18 said, whenever an interim order is passed by the High Court of no coercive steps to be adopted within the aforesaid parameters, the High Court must clarify what does it mean by no coercive steps to be adopted, as the term no courses to be adopted can be said to be too vague and are broad, which can be misunderstood and or misapplied. So far as the legality of the impugned interim order passed by the High Court in the present case directing the investigating agency, police, not to adopt any coercive steps against the accused is concerned, for the reasons stated herein below, the same is unsustainable. Milord, this has been said, why such unsustainability of this order, Milord? So, Milord, when the investigation is in a very nascent stage, evidence to be collected, Milord, then the investigation, because, Milord, then in the judicial proceeding by 226, Milord, if there is no such, Milord, only an imaginary figure that there is an attempted by a malafide or the abuse of power, they should not be interfered, Milord. The independent agency, Milord, we are investigating the matter, my lord, and then, my lord, it will come to the logical conclusion.
The basic issue is, where is the criminality? In absence of any criminality, how can you proceed?
My lord, if your lordship see the section 353 subclause 1 subclause B and 353 subclause 2, my lord, it is the criminality. And each and every word statement which has been published, my lord, this is the criminal acts, my lord. And also 267 is someone to be affected. That would be, I will not raise this with regards to that. But when there is a one cognizable offenses, definitely police has registered and the investigation is in progress. This is the criminality with regards to the when it has disclosed by when criminal complaint, my lord.
My lord, since Mr. Bhattacharya is here, with his permission, I want to only cite one judgment. This was argued by Mr. Bhattacharya before the division bench of this honorable court when Honorable Chief Minister of the state, while standing in West Bengal Legislative Assembly, said the judgments could be purchased. And there, the division bench of our court, comprising of the Honorable Chief Justice Jane Patel Diden, his lordship was, and Justice Bakshi, the beautiful paragraph.
That was Justice Mishra and Justice Bakshi.
And it was a beautiful paragraph. May I read it? Paragraph 27. We are therefore not persuaded by the submissions of Mr. Bhattacharya that the imputation of the context of the entire speech can be said to be one which transcended the Lakshman Rekha of scandalizing the court or obstructing the administration of justice or interfering in the due course of judicial proceeding. We are therefore unwilling to suo motu invoke our power to initiate for the contempt in respect of the aforesaid imputation. We make it clear that our reluctance to initiate such proceeding should not be taken as an approval of the statement made by the speaker. One must not lose the sight of the fact the speaker was not an ordinary personality but the Chief Minister of the state. It is expected that when criticism is made from such high constitutional functionary, the same should be laced with moderation and temperance. The imputations were neither moderate nor couched with temperate language, although the same in contextual matter, according to us, may not constitute. So, Lordship, judiciary in our country stands in a high pedestal. This cannot be imputed in such a fashion by anybody and everybody. And that is the consistent stand which Supreme Court has followed everywhere, Lordship. So, kindly watch it, Lordship.
I would again repeat, Lord, that if the FIR complaint does not disclose any cognizable offense, it does not disclose any cognizable offense. Criticism, interpretation, that might be wrong, right? That's a different issue, but that is not a cognizable offense. Police has no business to start to register an FIR and start investigation. This is absolutely harassing. Can you see the complaint, Lord? And who is state of PP? Well, himself, Lord, he's failed to give his own identity. There is nothing called PP for State of West Bengal. A person who misrepresents himself. If I may use that expression, very sorry to say, he's a lawyer. PP of state. Who has appointed as the state PP? And was he authorized by the state to lodge this complaint? He could have done it in his own personal capacity, but not in the capacity of the PP. Help করো।
With regards to that, Mr. Chaki's complaint, I can submit, my lord. Let it be, my lord.
Quashed.
Let it be, my lord. But this complaint, my lord, it has some substance, my lord.
Chaki's complaint quashed.
My lord, it
On consent.
Nothing remains.
My lord, consent means because if you lordship sees the ingredient.
Yes.
See the ingredients.
So you give consent.
My lord,
I'll record your consent.
my lord, I am interacting with my lord, consent to some extent is my submission before your lordship candidly. It cannot be constituted as a consent. I said that
It
this
ought not to be proceeded with.
maybe because
The manner in which the complaint has been
But
lodged.
this complaint of Otri Sharma, in each and every word which he has transcribed from the video footage or the published, that constitutes 357 353. So that requires to be to some extent investigation. And
So Mr. Chaki's complaint,
If the Chaki's complaint goes,
yes,
then automatically other complaint goes.
so there is a
These are
separate
fundamentally-
independent complaint by Otri Sharma.
But the content of all the complaints are same.
Otri Sharma is a bit detailed.
Might be, but detail
Chaki's
doesn't.
complaint is as vague as anything.
Yes.
But Otri Sharma has something which the state intends to proceed with. Now, what will happen, I will decide it. That is something different.
Lordship, you monitor.
First of all, let the PP is
without the
lodging
link
a
of the
complaint.
he will not do anything.
May I speak?
Yes,
But
please.
that complaint does not disclose any cognizable offense by an YouTuber. He has a better fundamental right to disseminate information. If any wrong information goes, that cannot be said to be criminal offense. The information, whether that incites the people to work against the state integrity, if that is so, then there will be complaint, otherwise not.
My lord, that information is a distorting and the false, my lord. If your lordship, my lord, I will invite lordship, which we have kindly examined our
criminal
CD.
complaint.
It has been seized, my lord. Kindly see at any point of time, your lordship will see in every word, every sentence.
Very well, I'll pass order. See, it's 1 o'clock. I am at